Commonwealth versus Hughes raises a question of when can the prosecution add a count of kidnapping to another crime um, when that extra count of kidnapping was necessary for the other crime to have occurred. So what are we talking about in this instance? Well, there are a couple of crimes, and rape and robbery are the two that come most immediately to mind that necessitate the defendant detaining the victim for some length of time. Now, we know that Pennsylvania's kidnapping statute requires that the person either be transported a substantial distance or detained for a substantial amount of time, with the purpose being to facilitate a felony. There are other mens rea that can attach to it, but we know that if you're detaining a person for a substantial period of time, or moving a person a substantial distance for the purpose of facilitating a felony, then that is one definition of kidnapping. Okay, so consider rape or robbery, and robbery is probably the easier one to talk about. In order to take a person's money by force, you have to, in the easy example, you put a gun to the person and say, your money or your life, and the person hands over the wallet. During that period of time when you got the gun on the person, that person, is not able to leave, because if you're demanding money, the person wouldn't just walk away. So between the interval of time between the gun being poised on them, the demand being made, and the money being handed over, the victim, certainly doesn't feel free to walk away. Is that a substantial period of time? Well, courts aren't really good about putting timetables on words like substantial, particularly in a context like this. As we've learned in other cases, the question is, what was the victim's age, mental status, how upset was the person by this whole scenario? That's how we figure out substantial. We don't say it has to be more than 38 seconds. There's no, clock that we turn on to determine whether the detention was for a substantial period of time. But what are we worried about? Well, the story here is that we're worried that the prosecution will stack the crime, that the prosecution will charge robbery and kidnapping because there was a period of time between the drawing of the gun and the collecting of the wallet where the victim was not free to leave. And why are we worried about that? Well, this is a unique historical quirk that goes back to the 1950s and 1960 in particular. When the drafters of the Model Penal Code wrote the kidnapping statute, there had been a case in California where Carol Chessman, a defendant who became a very famous defendant, he had been convicted of rape and kidnapping, and he'd been condemned to die. The victim didn't die during the course of this event. The victim was raped and kidnapped, and the question was whether the kidnapping was actually just part of the rape itself. As awful as that is, if the kidnapping was no more than necessary to commit the rape. And there's another caveat. In California at the time, kidnapping was a capital crime. And so there's this interesting historical accident at play in the Hughes case. You see in the Hughes case, the court express a concern about the prosecution using a kidnapping charge when it only is incidental to the underlying charge of, say, robbery or rape, to get a higher penalty. We've talked a lot in this class about how the prosecution has great ability to decide which charge to bring, and we really haven't worried about how prosecutors use that discretion. We are worried about it from a political sense in terms of who gets elected DA. But courts have given prosecutors the power to charge any crime that meets the statutory definition, and haven't really worried about whether this is what some would colloquially call overcharging. Does this sound like more than actually is at play here? If the statutory definition is met, courts haven't really concerned themselves with whether this enables the prosecution by sort of a trick to get a higher penalty. Kidnapping is the example. And that's because of this unique exception of Carol Chessman, who was condemned to die in California and was executed in California's gas chamber in 1960. And the reason that that case got so much attention, not just that it was a capital case, not just that Carol Chessman was executed for the crime of kidnapping, but the fact that Carol Chessman was probably the first literate death row inmate in modern American history. You hear oftentimes now about inmates on death row writing books. It's not as common as people talk about, but Carol Chessman was the first. He wrote 3 books, which were actually quite critically acclaimed. They made a movie out of his life, and there were in literary circles and in sociology circles, his books became quite the thing. And the concern was, how do we execute someone who is actually intelligent, who is actually contributing interesting ideas to society? The Pope intervened trying to prevent the execution of Carol Chessman, and it became just quite this national story. And it was within a month or two of the Model Penal Code releasing its report on its proposal for the kidnapping statute that they wanted to include in the Model Penal Code. So in it, they provided that you shouldn't allow prosecutors to use kidnapping to stack, to enhance the punishment for crime when the kidnapping is no more than what is necessary to convict the person of that underlying crime. So in Pennsylvania and in a lot of states, courts adopted that position of the Model Penal Code. It's nowhere in the statute that the kidnapping has to be more than merely incidental to the underlying crime, but this became part of the interpretation of courts throughout the country. And so when you find that the prosecution is charging the defendant for kidnapping in the course of a felony, that kidnapping has to be something more than would be necessary for the defendant to have perpetrated the crime that he's charged with, whether it's rape or robbery or some other underlying felony. If the kidnapping involved more than was necessary to carry that crime out, then the prosecution can charge the kidnapping as a separate offense, but otherwise can't. So that is an added interpretive gloss that courts have added to kidnapping in this state and many others, and it really is an exception to the rule that prosecutors can charge any crime, even though it doesn't feel like this is what they ought to be doing. Examples would include a burglary charge for a kid who goes into the 7-Eleven to shoplift a candy bar. That doesn't feel like shoplifting. I mean, that doesn't feel like a crime that ought to be added to shoplifting. Courts in jurisdictions that don't require an unlawful entry for a burglary have had no problem with that. Kidnapping is a special case because of the unique historical circumstances of the execution of Carol Chessman in 1960.